Welcome to U.S. Immigration TV. Now, I've been reading your comments and questions, and so many of you are asking about how to get your fiancé or fiancée to the U.S. And aside from that, I know there are so many movies or reality shows that focus on fiancé visas. Like many years ago, there was a movie Green Card, and today on cable, there's the 90-Day Fiancé. And I know it's hard for you to sort through fact from fiction, so make sure to watch this entire video to get all my tips as I discuss the K-1 or the love visa. And by the way, I've also had many people come to me for consultations asking perhaps the same questions that you have. How do I bring my boyfriend or my girlfriend to the US so we can marry and live happily ever after? Well, here are some important facts that are sometimes overlooked by people and are not as clearly shown on movies or reality shows. So let's get right to it. Some important tips and information about K-1 visas. Number one, the K-1 visa is available only for U.S. citizens. So therefore, lawful permanent residents or green card holders cannot file a K-1 petition for their loved one. Instead, they would either have to wait until they become a U.S. citizen and then file the K-1 petition, or travel abroad, marry the person, and then file a F2A petition, which is spouse of green card holder. Number two, in some cases, the K-1 visa may be the only way to bring your loved one to the U.S. Now, this could include same-sex couples and divorced Americans who want to bring their fiancé from the Philippines. Now, while same-sex marriage is recognized in the U.S., it is not in many countries. So therefore, marrying your same-sex partner abroad and petitioning them as a spouse would not be possible. Similarly, in the Philippines, divorce is not recognized. Therefore, a divorced American could not go to the Philippines and marry their loved one there. The K-1 petition allows the U.S. citizen to bring their loved one to the U.S. and marry them in the U.S. Number three, both partners must be free to marry each other. So in other words, both should be unmarried. So if either partner is still married to someone else, that first marriage must be terminated before the K-1 petition can be filed. And I want to remind people that separated is not single. I've come across many cases where a person has not seen their former spouse in many years, and so in their mind, they consider themselves single and free to marry. That is not the case. A person must be unmarried, either because they have never married, they're a widow or widower, or they had a previous marriage terminated through a divorce or annulment in court. Number four, the couple must have met in person within 2 years of filing the K-1 petition. So I know there have been travel restrictions, COVID lockdowns, etc., preventing people from traveling. So if, for example, the last time you saw your loved one was in, let's say, December 2019, then you have until December 2021 to file the K-1 petition. And if it's been more than 2 years since you last saw each other in person, you may have to travel abroad and meet again. Now, there are some rare, and I emphasize the word rare, exceptions, such as if a person's religion forbids them from seeing each other before the wedding day, or if the American can demonstrate extreme hardship to travel. But I'm telling you right now, that's really difficult, time-consuming, and uphill to prove. Number five, the U.S. citizen has to file the form I-129F, which takes approximately 8 to 10 months to process at the USCIS. Now, although the U.S. State Department and the embassies have stated that they will prioritize K-1 petition processing, it seems USCIS is not doing that. And you know what's worse is a spousal petition is taking over 2 years for USCIS to process. So I don't know why they're calling it an immediate relative if it's taking 2 years. So kind of like, think about it, even if a person is free to marry abroad and petition their loved one as a spouse, It could be faster to bring them here either on a K-1 or if they marry a K-3 visa, which is a different topic. Number 6, a K-1 petition can be extended by the consul if it has expired. Now, ordinarily, a K-1 petition is valid for 4 months. But during this time of COVID lockdowns, we had the Trump presidential proclamations. Many of the K-1 petitions that were approved have already expired. In that case, a consul has the authority to extend the petition and issue the visa without the U.S. citizen having to file a new K-1 petition because the old one had expired. Number 7, your loved one cannot come to the U.S. on a visitor visa with the intention to marry you and be petitioned. That's kind of like a way to bypass a K-1 petition. And that's important because if a person enters the U.S. as a visitor with the intention to immigrate or marry, that could be considered fraud. That's because they would effectively be lying at the airport when they arrive concerning the purpose of their visit. However, if after arriving in the U.S. as a visitor, they fall in love and then want to get married, that could be a different story and may not be considered fraud. Number 8, the couple must marry within 90 days of the person's entry into the U.S. And if they don't, that person has to leave the U.S. Number 9, if the couple marries after 90 days, the U.S. citizen has to file a spousal petition. This is because the K-1 status had already expired, but it has to be the same person. Number 10, a K-1 petition includes children under 21. A separate petition for the children is not required. Number 11, a K-1 petition provides a loophole for children over 18 to come to the U.S. And that's important for many people who marry a U.S. citizen, but they have children who are over 18 but still under 21. And the reason for that is under U.S. immigration law, in order for a U.S. citizen to petition stepchildren, they must marry before the stepchild's 18th birthday. So, like, what happens if the loved one has a child who's already over 18? So in that case, the U.S. citizen can bring their loved one as a K-1 and the stepchild to the U.S. on a K-2 visa, and the child will still be able to get a green card as long as the child arrives in the U.S. as a K-2 before the 21st birthday. Finally, number 12, a person entering the U.S. on a K-1 visa can only adjust status or get their green card in the U.S. through the U.S. citizen who filed the petition. If the person enters the U.S. on a K-1 visa and for whatever reason they don't marry that American, or let's say they marry someone else instead or are being petitioned by an employer, they are not allowed to get a green card in the U.S. Instead, they would have to return to their home country, most likely with a provisional waiver. So in other words, if you enter on a K-1 visa, the one and only way to get a green card is through the U.S. citizen who filed the K-1 petition. However, here's another important tip. If you do marry that American within 90 days and adjustment of status is filed, but get divorced before the green card is approved, in some cases it could still be possible to get your green card through that U.S. citizen despite the divorce. Now, obviously, I've not gone through every detail and step or form or requirement concerning K-1s. I've just highlighted some important tips that are often overlooked. But if you are thinking about bringing a loved one to the U.S., I would strongly recommend that you consult with an attorney who can evaluate your case and help you, prepare, package, and file the petition so you can be living happily ever after together in the U.S. as soon as possible. Now, I hope you found this video helpful and informative. And I really would appreciate it if you will, of course, like and share this video with others. And most importantly, subscribe, as I will be posting videos about immigration news, developments, and including amnesty whenever, hopefully, it happens, as well as helpful tips on various immigration matters. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.